Welcome to StudyIQ IAS. Today we have one of the top voice in India when it comes to Indian Constitution, parliamentary practices, Mr. PDT Achary sir. Welcome to the session, sir.
Thank you.
Before we dwell more into the details of Parliament and Constitution and democracy at large, sir, we want to know your era, the PDT Achary era, back from the streets of Kerala all together to the temple of democracy that is Parliament, how that journey has been, because people are watching and they are seeing you with respected eyes, how they can also follow the same path. So we would like, and our team was actually researching on it, so we would like to know the journey, कि Kerala से Parliament तक का सफर जो था, how it went.
Actually, I left Kerala in the year 1969. Towards the end of 1969. In fact, I came to Delhi in search of a job. There were some friends here in Delhi who invited me. Well, I did my MA, and after that, I was jobless, and there was no way I could secure a job in Kerala so easily. Therefore, I thought of trying my luck here, the national capital, which always attracted me. So I came here. I landed in Delhi on, I think, 25th December. So when I landed here, in fact, it was in Odissi, the train, I got a seat only in a train, which was using this coal engine.
Okay.
So when I reached Delhi, I was unrecognizable with a lot of dust and, I was totally black, of course. Otherwise, there was nothing to distinguish between that and my color. Landed here, my friends were on the platform. So when I came out of the train, I was almost virtually frozen. Because in those days, it was in 1969. Those days, it was terribly cold. December was very, very cold. And this kind of a cold I never anticipated. I couldn't even conceive, I couldn't even think of such a cold season, So I thought I was just stepping into ice. So these were, I didn't have any warm clothes or anything. I was not prepared for this. So those guys, they realized my predicament and they put me in the car and then took me home. And there they draped that razai around me. So after maybe 1 hour or something, I came back to life. Otherwise, I thought, well, I was frozen and finished. After that, of course, I applied for a post in the Parliament. Then was an interview and written test and all that. Then I got selected. That is how I started my career. That was in the month of March 1970. That is how I landed in Delhi. Then getting a job in Parliament, whatever be the nature of the job, was something which was unthinkable for me when I was in Kerala. So I felt very proud of the fact that I have been able to get inside Parliament. And from then on, started moving up. And finally, I ended in, as a Secretary General of Lok Sabha in 2005. Of course, I passed through various stages. Altogether, I spent 40 years in Indian Parliament. And of these 40 years, 5 years, I was the Secretary General. This is the career path.
Got it. To give you the context, since Sir has spent around 40 years in the Parliament, so we have to pick the mind of Sir on the nuances of Indian polity. Because before having this podcast, so he was having very interesting issues, or you can say interesting views with respect to Parliament. We would request Sir to openly share those views here as well. So starting from the Constitution itself, there's a lot of debate on basic structure doctrine. Is there any subtle threat to the very idea of basic structure?
Well, this basic structure doctrine was propounded in the Keshavananda Bharati case.
Yes.
In the early 70s. Keshavananda Bharati case, the previous judgments of the Supreme Court. In one judgment, the Supreme Court said the Parliament cannot amend the fundamental rights.
Yeah. Golaknath case.
Okay. And after that, the case went up before the Supreme Court, and a 13 judges bench dealt with this Keshavananda Bharati versus State of Kerala case. So all these judgments, were about the fundamental right and the dimensions of fundamental right. Because many legislations were struck down by the court on the ground that those legislations violated one fundamental right or the other. Basically, it was actually the right to property, which was a fundamental right in those days, which was the bone of contention. Many of these Mathathis and other property people, they challenged many of the legislations on the ground that these legislations violated the fundamental right to property. Keshavananda Bharati basically dealt with the actual power of Parliament, the extent of the power of Parliament to amend the Constitution. Because in Article 368, the Constitution provides for the mechanism for amending the Constitution. It says any part of the Constitution can be amended by following a particular procedure laid down in that article. Then the question is whether Parliament can amend every part of the Constitution. Then the court, they discovered this basic structure. They said the Constitution has something called a basic structure, and the Parliament has the power to amend any part of the Constitution, but they cannot alter the basic structure. Now, what exactly is the basic structure? What is the concept of basic structure? The court itself spelled out some of the aspects of the basic structure. For example, democracy, parliamentary democracy, republican form of government, independence of judiciary, federalism, secularism. These are the main aspects of the basic structure. So, even if Parliament has the power to amend any part of the Constitution, they cannot amend it in such a way as to destroy the basic structure. For example, you cannot destroy parliamentary system of government, democracy. Parliamentary democracy, you can't destroy. You can't switch over to the autocracy by amending the Constitution. Similarly, independence of judiciary, you can't take away the powers of the Supreme Court and other judicial forums. And then secularism. Although secularism as such is not mentioned in the preamble, it was not in the earlier stages. Later on it was added in 1976. But this Constitution was secular. And there are enough provisions in the Constitution which show that the Constitution is basically secular. Even if that word were not added to the preamble, Constitution would have been secular, was always secular, and would remain secular. So the Supreme Court said, no, you cannot alter the basic structure. You amend any part of the Constitution, doesn't matter, but you cannot alter this. That is the fetter, which the judges of the Supreme Court put on Parliament's power. That is the basic structure. Now, the problem is, this, as I said, this was a 13 judges bench, 7 majority and 6 minority.
Gee.
So it was a very closely divided thing.
Yes.
Now the danger is, suppose a government comes with a brute majority, say around 400 seats, or then they can influence the Supreme Court to constitute a 15-member bench and overrule Keshwananda Bharati.
Yes. So there's a legal possibility there.
Restore the power of Parliament to amend any part of the Constitution. They can say there is nothing like a basic structure. That was a kind of an imaginary thing. It is not there. Therefore, we rule it out. This can be said. So that danger or khatra is very much there.
Okay. Sir, if we compare with the UK's democracy, so there's a lot of trust with respect to Parliament. So why can't we have this kind of trust in Indian Parliament?
Well, the point is, you have a constitution. London has a constitution, but they don't have a written constitution.
Yeah.
All conventions and all that, you know. Their Parliament has evolved over centuries in their struggle against monarchy. Parliament, particularly the House of Commons.
Yes.
There was intense struggle between the monarchy and the House of Commons. The House of Commons extracted powers from the monarchy in course of this struggle. So Parliament became a very, very strong organization, body, representing the people. So Parliament's supremacy was always maintained there. That concept of parliamentary supremacy emerged from the long period of struggle between the Parliament and the monarchy. That is the history. We don't have that history. Here, if you go back to the pre-independence days, 1935, you know, for the first time, the British passed 1935 Government of India Act, which brought about the two houses and some kind of federalism. That's the thing. But vesting all the powers in the Governor General, that is the Viceroy, and then the governors in the states. That was the structure, you know, political and administrative structure which was there. And then when we made the Constitution, much of what was there in 1935 Government of India Act was taken from there and put in our Constitution. So the Constitution actually is patterned on that. And when the Constitution has been adopted, you know, it created these institutions. In Britain, it is the other way around. There, the whole system emerged out of a struggle.
A demand. So
here, that was not the case. Here, the Constitution created these bodies. Constitution created Parliament and the legislatures in the states. Constitution created the executive, which is responsible to the legislature. Constitution created the judiciary. So Constitution is supreme and not Parliament. Parliament is supreme in respect of legislative power. No, there is no body, there is no power which is above Parliament so far as lawmaking is concerned. That is how things have been decided. These bodies have been created by the Constitution. So Constitution is supreme, not Parliament.
So, are you saying that Indian Parliament seems to be less mature in comparison to UK's parliamentary history because they are modeled on the basis of demand? There's a, you can say, sync between how people are imbibing the values of democracy, and in similar way institutions are being created. But in case of India, institutions were formed, but the people who are going to elect these parliamentarians, those values were not perlocated that much. So can we deduce that?
Well, I will not say the Parliament is less mature or anything. That formulation may not be correct because we must look at it from another aspect. You know, when we started out, we introduced the universal adult franchise without any qualification or anything. Every voter, every person in India, every citizen was a voter. And therefore, there was a certain presumption that the Indians are mature enough to decide their destiny. They are mature enough to make an intelligent selection of people who will rule them. That's the thing. And right from the beginning, the people of India, although the literacy was very low, but these are the people who elected governments. And if you look at the history of the governments which came to power at different times, starting from 1952, we had a Prime Minister who was a very towering figure, Pandit Jawaharlal Nehru, a world statesman. And he had ministers who were also very, very important people who participated in the freedom struggle, who were great leaders, approved by the people, liked by the people, loved by the people. They elected them. That's the thing. So they had shown maturity to elect such people to rule them. So how can we ever say that the people, although many of them were illiterate, were poor in their choice or immature, as you say? No.
We can conclude this in a manner. Sir has beautifully stated that, giving you a context, there was a philosopher, J.S. Mill, who at one point said that India should not have democracy because Indians are barbaric. He was a reluctant Democrat. Colonies में democracy नहीं चलेगी, India में नहीं चलेगी. And at that point of time, Jawaharlal Nehru and Mahatma Gandhi ji was saying that democracy should knock at the door of Indians, the last man who is standing. So that is the, you can say, maturity of Indian democracy, that illiteracy का मतलब या जो values हैं of democracy उनका पता होने का, ना पता होने का मतलब ये नहीं है कि India was not deserving democracy. Sir.
So मतलब all those students who are watching, first let me tell you that this is a serious podcast. ठीक है, तो आपको थोड़ा सा उसी इंटेंसिटी के साथ इसको पेशेंटली वॉच करना पड़ेगा. एट द सेम टाइम दिस इज डेमोक्रेसी इन एक्शन एंड यहाँ पर लक्ष्मीकांत एक्चुअली में अनफोल्ड हो रही है.
बिल्कुल
ठीक है. तो आपने जो भी सारी चीज़ें जो बुक व्यू पढ़ा है उसका एक्चुअली में टुडे वी आर सीइंग द फील्ड व्यू ऑफ द बुक. सो अगर सर मैं यहाँ बात करूँ अगेन नाउ गोइंग इनटू सम ऑफ द कंट्रोवर्शियल एस्पेक्ट्स ऑफ द पार्लियामेंट एंड डेमोक्रेसी,
एक छोटा सा कंटेक्स्ट में देना चाहूँगा. जो भी आपने कंटेम्प्रेरी डिबेट्स अभी सुनी है, चाहे वो गवर्नर की पोजीशन हो या प्रेसिडेंशियल रेफरेंस हो या आर्टिकल 142 है, उन सभी पर डिस्कशन आने वाला है.
Sir, so I was having this thought and we also discussed in the hindsight also that going with the Darwin's thought of evolution of the species, so there is also evolution of the institutions as well. So how you see the evolution in the sense that we have two big eras in the contemporary times. There is Manmohan Singh era and then there is Modi ji's era. So how the institutional build-up and the evolution has happened over the years?
See,
you can choose to be subtle also.
Yeah, but you see the point is, let us not think that evolution has been a very linear kind of development. Okay. There are ups and downs.
Yes.
So as it happened in the evolution of man, the species, so in the institutions. So there were ups and downs. There will be ups and downs. After all, in Britain, Great Britain, Parliament, I said there was a long struggle and all that.
Yeah, there was a long struggle.
But there were many situations, you know, where Parliament was down, monarchy was up.
Yes, yes.
What happens?
So epidemics and pandemics can come in that evolution.
Yeah.
Point is, where are we right now?
Yeah. So it's a part of the whole process. So here also the same thing.
Yes.
Now, I do not want to make a value judgment of different personalities who came to occupy the post of the Prime Minister who led the country in a particular period. Everyone has his or her own merit. And everyone has his or her own demerit also. It's a mixed picture. Therefore, Manmohan Singh represented a particular thought, ideology, all that. Dr. Manmohan Singh was a very world-famous economist. And he had, before becoming the Prime Minister, he had held many important positions here. And he was an authority on economics. An economist becoming the Prime Minister, that happened for the first time in India. So from that point of view, it was a very unique period. And I can say, because I was Secretary General during that period,
Yes.
I can say that in 2008, you know, when that subprime crisis, you know, that
US.
Yeah,
economic
US subprime
meltdown
crisis.
happened,
Yes.
he was the man who led India.
Yes.
And during his period, you know, India had achieved tremendous growth in the economy. And in the whole world, it was being discussed. And I remember to have read articles in the Time magazine about India going up and surpassing even China. 8% growth, 9% growth, it was moving up.
Yeah.
It was then that this economic crisis came about in America. And that affected economies in the whole world except India. India could hold on without suffering much because of the very competent management of the economy by a person like Manmohan Singh.
Yes.
But he doesn't make unnecessary claims or he doesn't blow his own trumpet. But he was quietly managing the crisis. That is what I felt, you know. So he is a man who quietly does things efficiently, competently, for the sake of the economy, for the sake of the country. But there can be a person who will make a lot of claims and announce his achievements and all that, but personalities differ. That is the thing. So ultimately it is for the historians
Yes.
to judge. But since I am not a historian, I will not judge
Yes.
the personalities, their achievements, their merits and demerits, and what kind of system they built up, whether they improved, strengthened democracy, or whether they weakened democracy. All these things should be left to the historians. It will take some time for them to make a judgment of this period because it is too close.
Yes.
Therefore, it is not very wise for us to sit in judgment on this period.
Just इसमें एक thought.
जी.
So it is a very politically correct description you have done. So एक और ethics के paper के अंदर we have a topic called as political neutrality. So sir, you were in the linchpin of the democracy in the parliament. So how you were able to keep up your political neutrality in that ocean of high political pressure?
Well, this is a question which used to be asked of me by many people, including members of parliament. How can I remain so unruffled and unaffected by anything that is going on there, and catering to the needs of members of parliament belonging to all the parties. So when you enter the Lok Sabha, this is a lesson which is given to us. For us, there is no party or anything which exists. It's only a member of parliament who represents the people of India. They are elected by the people of India and they have to be served. So the service of members of parliament, whichever party they belong to, whether they are ruling party members or opposition members, सबकी सेवा करना है.
True.
ये था हमारा basic lesson. So we don't look at them from party angles. Oh, he belongs to the ruling party, so he should be given a little more importance. And the other fellow, you know, he can be ignored and things like that. Not at all. And we can certainly maintain that position. That is why, and particularly a person like Secretary General, you know, he has to be impartial and objective. He cannot look to this side or that side. He can't take sides. That is the thing. But in Parliament, you must understand one thing. Government has primacy so far as parliamentary business is concerned. Government business has priority over other business. The Speaker has a duty to ensure that the government's business is done, completed. Otherwise, you know, the country will suffer. But at the same time, Speaker has to listen to the opposition and meet their demands. It used to be said, the opposition will have its say and the government will have its way. So, this is the basic principle. Therefore, a Secretary General has to see that number one, the government business is transacted without any hindrance. At the same time, he has to see that the opposition their demands are met, reasonable demands. We have institutional arrangements where the government and the opposition come together, they discuss among themselves what is to be discussed in the House, or when it is to be discussed, and how for what duration, and all that. So there is an institutional mechanism which takes care of that. That's the thing.
BAC is take care of that Business Advisory Committee.
Yeah, Business Advisory Committee. That is the mechanism. The Speaker is the chairman.
Yes.
Ministers are there, and then the leaders of the opposition are there. The Secretary General is there. It is discussed, and things are decided. Yes. So such and such subjects can be discussed, and we will allot this much of time. All that kind of thing, you know. And that is a very effective mechanism for smoothening the whole process of transaction of business in the House.
Sir, can you please elaborate in what way Secretary General's position is crucial? Means kind of decisions which lie with Secretary General, the kind of demands which can be fulfilled for opposition side.
See, when these opposition members, they give notice of various subjects for discussion. Of course, those subjects may not be liked by the government. They will be naturally critical of the government, or those subjects may be relating to the failure of the government in some area. So, government may not readily agree to that. That is why this mechanism, you know, this Business Advisory Committee, there a consensus will be arrived at. And on the basis of the consensus, certain issues will be discussed. But before that, before it takes place, you know, the Secretary General will examine all these various demands or subjects, the notices. You know, we are guided by the rules of the House.
Rules and procedures, yeah.
These rules are the touchstone. These are the kind of touchstone on which it is tested. I mean, everything is tested, all the notices, whether they conform to the rules or not. If they don't conform to the rules, then they will not be admitted.
Okay.
That is the thing. Where Secretary General has to look at the rule and see whether it conforms to the rule.
Okay.
That is the only thing which, but then he also, because he has to advise the Speaker. He is not the deciding factor.
Yes.
But he has to advise the Speaker on the admissibility of things. So he will advise the Speaker. So these are the things. This can be admitted or this cannot be admitted. And the Speaker will take his own decisions. After all, Speaker is this ultimate authority. This is how the system operates. Now, we do things in such a way that the opposition will not have any kind of reason for complaint. And if they make a complaint, it will be against perhaps the Speaker or the government. Because after all, the Speaker is a deciding authority. Secretary General is not in the line of fire
Okay.
because he only advises the Speaker. That's the thing.
And there are grey areas within the rules and
But
procedures.
I can tell you
Yeah.
an interesting, I'll tell you an interesting episode. When there was a notice given by Madam Sushma Swaraj, who was the leader of the opposition at that time. They gave a notice of an adjournment motion. Adjournment motion, you know, is a censure motion.
Yeah.
That is why governments normally don't allow this. They disapprove this, and they tell the Speaker not to allow this. And the speakers normally they disallow this.
So to give context to our students, when adjournment motion is in place, then agenda of the day of the sitting is actually sidelined in order to take up that issue.
Yes, yes. Adjournment motion means you adjourn the discussion on
Yeah.
all other items which are listed in the agenda
Yes.
and take up this.
Yes.
So there is great urgency about it. And then the leader of the opposition, Madam Sushma Swaraj, gave a notice, and the entire opposition was with that, in support of that notice. I don't remember exactly what the subject was. But then the government was, caught unawares. On that day, there were not enough members in the ruling party at that time. People had gone back to their constituency or things like that. Because nobody could anticipate such a thing was coming. And government did not want to take any chance on that. But then you have to go by the merit of the subject. Then ultimately the burden fell on me to give a proper advice on this subject. So I examined the whole thing and examined it in terms of rules and also the rulings. Speaker's rulings, you know, these are precedents. And I found that there was no responsibility of the union government involved in this episode. No responsibility. In the adjournment motion, there is one condition which says that the government should be responsible for that. That means government's responsibility should be there. This is something which I spotted. I said, the government's responsibility was not there. So I located the ruling and then I told so Mr. Pranab Mukherjee was the leader of the house, Mr. Pawan Bansal and Prithviraj Chauhan. They came to my house and sat with me, and then I told them, look here, this is the thing. So they went back to the Speaker and told her that, Madam, this is the position, we are safe now. The next day when the motion was taken up, you know, Pranab Mukherjee stood up and he virtually read out what I wrote as a ruling or some kind of thing. I mean, not ruling. Ruling is given by the Speaker. Given, and the Speaker gave that ruling and disallowed the motion. And after that, when I was sitting with the Speaker in her chamber, Madam Sushma Swaraj came in and she said, Madam Speaker, so long as Mr. Achary is the Secretary General, we will never move an adjournment motion in the House. So she knew that it was my advice. So Secretary General actually can give such crucial advice. That is there.
Also in the crucial situations where, for example, TMC MP for Moitrai's case, whether a particular case need to be taken by the ethics committee or the privilege committee, so Secretary General plays the crucial role, right?
Yes. And I have written also about that.
Yes.
In that particular case, you know, it should have been handled by the privileges committee because it was a question of privilege. It was not a question of ethical behavior or anything. Ethics committee, you know, deals with certain other things. The moral vagaries of members and all that kind of thing. There are many such cases, you know, members went to went on a tour with parliamentary committees with their mistresses, and their wives made complaint and all that. So they were brought before the committee, and their explanation was sought, and they were barred from any committee tour, you know, after that, and that kind of thing. This committee deals with that. But this was a different kind of situation. But there the ethics committee did it, and then she was expelled perhaps from the house and all that. Well, I do not want to say anything more on that thing. But I always felt that it should have been properly handled by the Privileges Committee.
So since we were talking about speaker, do you think we need to bring certain changes, institutional changes, some legal changes in the position of speaker so that we can have neutrality as a safety net?
No, it is difficult to bring about any legal changes because there is no law which governs the behavior or conduct of the speaker. Speaker's position has evolved in England over a period of time.
Yes.
And speaker, identifies himself with the house. He is the custodian of the rights of the house. And he is the protector of the house, the privileges and the rights of the members. That's how the speakership evolved. There was a very interesting case in England. I think it was in the 16th century or something. The members of parliament, some members of parliament, spoke in the house against the monarch, the king, I think King James or somebody. And they were charged with sedition by the king. So one day, and they took refuge in the House of Commons. The king came to the house, with his bodyguards and all that, fully armed, all that. Came and knocked at the door of the House of Commons and entered the house, and went to the speaker's podium, and the speaker immediately got up, vacated the chair, and he sat there and told the speaker, "You hand over those members against whom there are sedition charges." The speaker knelt before this monarch, the Rajya, the king, and said, "Your Excellency, I have no eyes to see, no ears to hear. Here I am the servant of this house, and I will do only what this house commands. I am sorry, I express my regret that I cannot comply with Your Excellency's request."
Classic statement to be used in ethics, GS paper 2 as well as an essay. So in case of UK, so there's a practice that speaker has to resign from the political party. So one thing I think that can be at least introduced, but that's not enough. So can we actually amend Schedule 10 and take away this power related to anti-defection law which lies with speaker? So these kind of...
Well, that is a question on which the opinions are divided. As per the Supreme Court in Kyoto Holohan case, the Supreme Court has reposed great faith in the impartiality and objectivity of the speaker, because speaker deals with an issue which arises in the house and also in the political party. That means speaker is more familiar with this than a judge sitting in the court or anybody else. And that is probably why the lawmakers made the speaker as the umpire, as the tribunal who decides the issue. That is okay, it is logical. But then how the speakers behaved in deciding these cases, there can be difference of opinions. So naturally there were demands that it should be taken away from the speaker, because there were cases where the speakers did not decide at all cases.
Yeah.
It dragged along.
And term was completed.
And the whole period got over
Yes.
without deciding the cases. And then many decisions were in favor of the ruling party.
Yes.
All that. So, in many cases, PKs were not very impartial. But the court has not actually paid much attention to that aspect. Speaker's impartiality or Speaker's unsuitability to decide the cases of defection. It continues to be there. But there is an issue which bothers the court. That the Speaker takes unduly long time to decide things. One is deciding case in favor of the ruling party. Second is not deciding cases in time.
Yes.
This is a problem which has been dealt with by the court. And the court earlier, a two judges bench, decided, when I think Justice Nirmaan was there, that within 3 months you must decide. That is the thing.
Okay.
Now the court has veered round to the view that within 3-4 months, the Speaker should decide. Because this is not a very complex matter. You don't have to collect a lot of evidence from different parts of the country and things like that.
Exactly.
You decide it on the basis of the law contained in the 10th schedule. That's how it is.
So it means you feel when it comes to Speaker, the challenges that we are observing in past, like Aadhaar bill being declared as money bill, or say opposition MPs in good numbers being suspended. I saw one of the article written by you on that, or say anti-defection law. So in these cases, we need to trust the current process and let judicial activism play its part whenever situation arises. There's no other way we can have within the House procedures evolving so as to expect more neutrality from the Speaker?
Well, it is not that easy because Speaker belongs to a party and the Speaker thinks that he belongs to a ruling party and therefore he should help the ruling party and the government. If Speaker thinks that way, then there's no way we can get out of this situation. But Speaker doesn't have to think so. Because Speaker is Speaker and Speaker can afford to be neutral as far as possible, reasonably neutral. As I said in the beginning, Speaker has a duty to ensure that the government business is completed in the House. Okay. But at the same time, Speaker has to look at the opposition side also. What are their demands? After all, what does the opposition demand? They want discussion. They are not asking for anything else. They want discussion on certain items which they have in mind, which are politically important for them, naturally. And but the Speaker, the government doesn't want, the Speaker will not allow it. That situation should not be there. That is, Speaker should look at examine the merit, examine the subjects in terms of merit and allow it. Because after all, the government has a majority. If there is a motion which is coming, a general motion or other motions, then the ruling party has enough of strength, they can vote it out.
Yes.
The opposition will have the satisfaction of having said whatever they wanted, and the government will be able to vote it out. This is what happens. So why should the Speaker take sides there? Speaker doesn't have to. That's why I said Speaker doesn't have to. He can afford to be neutral. From my 40 years of experience in Parliament, I can say that Speaker can afford to be neutral. Because Somnath Chatterjee was a Speaker who was absolutely impartial and objective, neutral.
My next question was this.
Yeah.
So can we compare Somnath Chatterjee's tenure with Sumitra Mahajan's tenure? Same institution, different personalities and different gameplay.
Well, personalities matter. Personalities differ from each other. Somnath Chatterjee became a Speaker and he was in Parliament, since 1971. He had had long innings in Parliament, you know. And therefore, he was well versed in the parliamentary practices and procedures. And then he was a lawyer, outstanding lawyer. So he would judge the issue on its merit. He told me, the adjournment motion I will allow based on merit. That's what he said. No speaker would say that. And he allowed it. And there, of course, it is, the burden is on the Secretary General to suggest. And I suggest that this matter be discussed or the matter be disallowed on this ground. But I specify the ground in the file. I said, these are the grounds on which we can allow this subject. Or these are the grounds on which we can disallow this subject. That is my job. And Chatterjee would take a decision on the basis of that.
Okay. And that's why Mr. Chatterjee was having a lot of respect across the party lines.
Yes, yes. He would take a very objective view of things.
So with respect to this trend which has, you know, we have seen deputy speaker position, no election, what's your take on this and what's the solution?
Deputy speaker should be elected along with the speaker, one after the other. That particular article, you know, says that these two offices of parliament, they are called offices of parliament in the constitution. They should be elected as soon as the house assembles after the constitution of the house, after the election. So it's a mandatory provision in the constitution. That means it should be followed strictly. That means we must have a deputy speaker. But unfortunately, for quite some time, there has been no deputy speaker. In the last Lok Sabha, there was no deputy speaker. In this Lok Sabha, more than a year has passed since the constitution of the new house, but no deputy speaker, no sign of deputy speaker being elected. That is the thing. But if you go by the rules, the government has no role in that. If you go by the rule, the rule simply says the speaker will decide the date of election. So the burden is on the speaker. He will decide the date. Suppose the speaker today decides that on such and such days, I have chosen this particular date for the election of the speaker and leave it at that. Everybody will be compelled to file nomination. That is it. So it is the speaker who has to decide. In the case of speaker's election, it is the president. In the case of deputy speaker, it is the speaker. So why doesn't the speaker choose the date? He has to simply announce the date. That is not happening.
Why that's not happening?
It's not happening because the government doesn't give any clearance. I mean, the government has not given a signal, perhaps. You know. That is how the system works here.
What's the reason? Means
I don't know.
They're not following the constitution.
We are not actually. I am really baffled by that. I am not able to find a reason why a deputy speaker is not being elected. The government has the freedom to choose a person from the ruling party, make him the deputy speaker, because there is no rule which says that deputy speaker should always be from the government.
But there's a convention, right? From opposition.
But convention is not rule.
Yeah, convention is not rule.
There's only a convention. And that too in the earlier stages, in the 50s and all that, you know, the deputy speakers were from the ruling party only. Later on they switched over to this just to maintain a kind of balance in the house. That's it. So it was a healthy, healthy convention. And there is nothing wrong about it, or there is nothing wrong is going to happen to anybody if you choose a man from the opposition as a deputy speaker. After all, sitting there in the chair, you know, he has to go by the rules and the constitution. He has to run the house as per the rules and the constitution. That is the thing.
So you feel there's no reason?
There is no reason.
There is no reason.
There is no reason. And I can't make a guess why the government is not giving signal to the speaker. That's it.
Sir, our former chairperson of Rajya Sabha, former Vice President of India, made a statement regarding Article 142. And within that speech, there was debate which was emerging that judiciary versus legislature is the current trend which is happening with respect to, there's a tug of war which is going on with respect to interpretation of constitution, judiciary interjecting some of the parts of parliament. So what's your take on that?
You know, there is a separation of power under the constitution. Judiciary, their role is to preserve and protect the constitution and examine the laws made by the legislature in terms of the constitution. And if there is a violation, if a law has been made which violates the constitution, that will be struck down by the court. That's one thing. And it scrutinizes the actions of the executive, and if there is any violation, that action will be struck down by the Supreme Court legally. So, protecting the constitution, defending the constitution, that is the role of the judiciary. And protecting the constitution means protecting the rights of the people. That is the thing.
But for that, don't you think Supreme Court is behaving like imperium within imperium? It's like state within state.
See, that is, I think, a journalistic phrase. That perhaps is not very correct, in my view, because you know, the judiciary has stepped into certain areas and given instructions when the executive has withdrawn from there. You know, in our system, there cannot be a vacuum. In the state, there cannot be a vacuum. If one organ fails, the other organ takes over. That's how it is. Here, many things are done on the instruction of the court because the executive has failed to take action there. That's the thing. And then the executive itself allows the judiciary to escape the responsibility, allows the judiciary to step in and take decision. This also happens. There are so many examples here. That is when the judiciary comes in. Then it is the job of the judiciary to interpret law. I will give just one or two examples. Article 21 is the pivot of the Constitution. That gives you immunity from certain action by the executive. It means your life, right to life and
personal
liberty.
Yeah.
That cannot be taken away by a law made by the legislature. The law has to be just and fair, due process. But due process has come in very late. Initially, the Supreme Court interpreted this particular provision in a very technical way. That means if there is a law, there is a procedure, and that's enough. The procedure need not be fair and just. The due process doctrine, which is there in American Constitution, was brought in 1978 in Maneka Gandhi's case. So it was an interpretation by the judiciary. And then through interpretation, the scope of Article 21 has been widened so much. That is the thing. I mean, that's a sign of a civilized society. You know, in a civilized society, citizens have a certain rights, and those rights should be protected. Only then you will be able to protect democracy. So the Supreme Court's judgment, interpretation of law or constitution has been to protect democracy.
But sir, sorry to interrupt. When Supreme Court has interpreted Article 21 and there are other actions as well, which for which we regard Honorable Supreme Court, but when we go to say NJAC, so can we say that having this projection that Supreme Court has protected India's democracy, Supreme Court is also having leeway to actually duck this responsibility of accountability, transparency when it comes to, say appointment procedures, say collegium system?
So there are two aspects to it. One is, look at the background of this collegium system. Earlier the executive was the sole decision maker on the appointment of judges to the higher courts,
yes.
High Court and Supreme Court.
Yes.
So, executive means a political party. They form the government. They have their own priorities, their own preferences for individuals, for persons, personalities and all that.
Yes.
They would like to induct them into the judiciary.
Yes.
Judiciary is supposed to be impartial, objective, and judicial independence is a part of the basic structure.
Yes.
It's not a meaningless expression. A part of the basic structure. So their job is to preserve, defend and protect the constitution. That's the thing. And when you are going to pack the judiciary with your own ace men, and which was happening. And based on this experience, the court said that consultation is concurrence in this case. They have done that. That interpretation was given to protect the system. That's it. To protect the system. Otherwise, what would have been the damage they would have caused, the executive could have caused to the system? That is one aspect. So, the collegium system, that means consultation with the Chief Justice, that was the provision in the Constitution. Consultation is not a mere consultation. Consultation means concurrence. Then you must have the concurrence of the Chief Justice. But then they further expanded it. Concurrence of the Chief Justice alone is not enough. Chief Justice is one individual.
Yes.
So to make it more democratic, you must have a certain number of judges sitting together.
Yes.
That's the logic behind it.
Yes.
Now of course you can take a very kind of position, saying that, see, Parliament is supreme and Parliament represents the will of the people, and it is actually Parliament which should decide, and the executive is a creation of Parliament. So they should decide who should be a judge there. That kind of thing, people can argue that.
Yes. These kind of practices are there in other nations.
In other nations.
Yeah, where executive
but then
legislature.
The point is that two nations are not alike.
Yeah.
A lot of difference.
Yeah.
We must understand how the system has evolved and worked in this country. What kind of impartiality you can expect from the executive, political executive. We are not living in a world of make-believe. We are faced with reality. The reality is there is an executive which has certain known preferences and ideological orientations. And then the Supreme Court will be packed with, or High Court will be packed with people who have a particular political persuasion. Is that good for democracy?
So what is the harm? Means if people are choosing those kind of politicians and those politicians are preferring a particular kind of judiciary, we have seen these kind of systems in several other nations. So it means people are preferring these kind of people in parliament or in, say, executive. And if people are not happy, then people are going to change those people in the next election.
See, it's easier said than done. People are going to change them merely because they have put wrong judges on the bench. That's not how it is. People don't decide things on the basis of that.
Sir, I guess we are running a bit late.
Okay.
Because there are other podcast sessions are lined up.
Oh.
So let us quickly wrap up in
Yeah.
next 2-3 minutes.
Oh,
Okay.
I see.
And
Time ka pata nahi chalega.
one good thing that I observed, so many students who will be giving the interview for UPSC exam 2025, sir will be also in the interview panel.
Yeah.
And at the same time, looking at the things, sir was able to give the answer that why deputy speaker might not be getting elected, because he might with his experience can give that answer, but he said that he will not be giving a blind guess. So that kind of answer UPSC aspirants should also learn that if you don't know the exact details and technicalities, you should not answer.
Even if you know, you need to know how to balance.
Yes. So, sir, in the last session of the podcast, so we have a rapid fire round in which you are allowed to only say the answer in few words or maybe a statement. And this particular section of the podcast is called as Sansad, Statutes and Smiles. So the first question is, coalition government has chaos and majority government have control. As a Secretary General, which one gave you more headaches?
It is the majority government.
Okay. If you have to pack a survival kit for Indian democracy, which 3 constitutional provisions would go in first?
Well, the most important constitutional provisions are, number 1, the citizenship.
Yes.
Number 2, the federal provisions. India, that is Bharat shall be union of states.
Yes.
There certain provisions have to be amended to make things more clear. But I will not spell out those things now because there is no time.
Yes. Third question is, if you had to describe a perfect parliamentary session in just 3 words, what they can be?
A perfect parliamentary session is where the opposition gets adequate time to discuss the issues which they consider are important. That's it.
And last 2 questions. Your advice to first-time MPs in 1 sentence.
They should, first of all, they should study the rules and the procedures, keenly watch the procedures, and try to understand the parliamentary proceedings, particularly the budget papers, and then the legislative measures. It's a constant kind of exercise, and they should do that.
And last question is, if you could make one rule mandatory to all the MPs?
Well, the MPs should attend parliamentary committees without fail.
So, sir, I would like to conclude from my end, and then you can conclude in the final sentence because the podcast is. While we were researching for this podcast, so I came across a very beautiful Hindi share on this. So it says कि जमहूरियत की journey के अंदर, in the journey of Jamhuriyat or democracy, there can be days which are shiny, there can be days which are glooming, but it is important to continue that journey. And we will congratulate you, and we have deep respect for you to keep us entangled in that journey of the parliament and the democracy from last 40 years. And I would like to end with 3 important keywords of parliament and democracy, that is dissented, disagreed and deliberative. With this thought, I guess we should conclude this particular podcast. It was very nice talking with you. It was a flow of wisdom for you from your end, and we could have continued this session till the late night also.
This is start of our session series with PDT Achary sir. And we would request sir to give some time in future as well, and then we are going to have those questions. Like sir was highlighting, there are some aspects of constitution which can be amended. And there are a lot of debates regarding constitution which sir can play on nuances like you have not read in your books.
Well, I must say that I thoroughly enjoyed this discussion, and then I was very pleasantly surprised by the range of knowledge that you have about the parliamentary system and also the constitution and all that. Because normally I don't expect such a deep knowledge about things relating to parliament and the constitution in other areas. But here, I was very pleasantly surprised, and I certainly, whenever we get an opportunity, I will be only happy to discuss various other aspects relating to the constitution, which of course is a time-consuming thing. But people also may get bored by the discussion on the constitution and all that, because these are all.
Sir, we actually think like this, but nowadays people want to know things beyond books as well, because UPSC is asking these kind of questions which want aspirants to think tangentially about the issues. Like in this means as well, UPSC has asked questions on certain key principles on which people generally know 2-3 lines.
Yeah.
But when we debate and get into the actual practices, people would have a lot of content. Which
So
is
there
what
is
they-
something called creative interpretation of,
Yeah,
the,
Yes.
of the constitution and the law and all that. You know. That is what we should aim at.
Yes.
Creative interpretation.
Yes,
That
yes,
is,
yes,
the facts are there.
Yes, sir.
Then you have to apply your mind.
Exactly.
And then interpret them
Yes.
creatively.
Yes,
That's what
yes,
it is.
Let's wait for next creative interpretation.
Okay. So thank you, sir.
Thank you, sir.
Thank you. Thank you so much.